We are now again to the last provision of the Provisional Remedies, which is Rule 61 of the Rules of Court, or what is known as Support Pendente LIte. So what are the components of support? So the support granted may be in money or other forms in accordance with Article 194 of the Family Code, which provides as follows: all in keeping with the financial capacity of the family. That A, everything indispensable for sustenance or for food, for the nutrition of the family. Letter B is dwelling. Letter C, clothing. Letter D, medical attendance. E, education, and of course, F, transportation, in keeping with the rights also of a person. So, who are the parties obliged to give support? So, in relation to Article 194, so we will read Article 195 of the Family Code that provides that the following persons are obliged to give support. Of course, number one are the spouses, and then second are the legitimate ascendants and descendants. Number three, parents and their legitimate children, and the illegitimate children of the latter. Okay, so illegitimate children of the legitimate children. So that's what it means. And number four, legitimate brothers and sisters, whether of full or half blood. So these are the um, parties who are obliged to give support to each other also, as provided in Article 195 of the Family Code. Now, support pendentilite of Rule 61, if we read Section 1, this is the application of the provisional remedy. So when is it available? So this remedy is available only in an action for support, or in an action where support is among the relief prayed for. So remember that an action for support, as well as in an action where support is among the relief prayed for. Okay, so and how is it applied, or how do you apply for support pendentilite? Now, it may be sought by a verified application filed in the court where the proper action is pending. The verified application may be made in the verified complaint or petition in the suit itself, or in a separate motion or petition supported by affidavits. So if the suit, if you have already identified that there is support pendentilite, and so during uh, the during the application for the support, it should be with the suit itself, or it could be in a separate motion. It's still applicable. So what are the contents of that application if you do so, no, in the court? The application must state, number one, the grounds for the claim, and two, the financial conditions of both parties, so that the court, in a practical sense, no, in a common sense, so that the court will also know uh, if the parties are really in need of support, or if the other party, which the party who seeks support, also is capable of giving such support. Okay, so what are the grounds for the claim? So, for example, you need the the needs, no, the first one, no. So if you go back to the components there, so these are uh, the grounds of your support Pendente LIte. Okay? So the application shall be accompanied by affidavits, depositions, or other authentic documents in support thereof. Okay? So it should have some support also. When will it be filed, or when can you file a support Pendente LIte application? So it is said here that at the commencement of a proper action or proceeding, or at any time to the judgment, prior to the judgment or final order. So you can apply support Pendente LIte at the commencement. So as we have read before, that it can go with the main suit. So the application can go with the main suit, or it can be applied in a separate motion as long as it is not beyond the judgment or final order. It should be prior to. So before any judgment or final order is being given, the application for pendente, support Pendente LIte can be applied for. Okay. So what is the jurisdiction over action for support? In the case of Baito versus Sarmiento, 109 Philippines 148, the it is said that RTC has exclusive original jurisdiction because the subject of an action for support, regardless of the amount claimed, is not capable of pecuniary action. Of course, it is a suit for support. It is a provisional remedy for support. It is not really on the amount claimed. Okay, to continue, an action for support does not only involve the determination of the amount to be given as support, but also the relation of the parties, the right to support created by the relation, the needs of the claimant, the financial resources of the person from whom support is sought, all of which are not capable of pecuniary estimation. So, that is the decision of the court that the RTC has jurisdiction over, as the court had said here, exclusive original jurisdiction for the for support Pendente LIte. Okay, so let us go to section 2, comment. A copy of the application and all support documents shall be served upon the adverse party, who shall have 5 days to comment thereon unless a different period is fixed by the court upon this motion. The comment shall be verified and shall be accompanied by affidavits, depositions, or other authentic documents in support thereof. And so, the answer of the adverse party is called a comment in the application for support Pendente LIte. So the same thing that the adverse party to whom you are claiming to for the support shall comment 5 days uh, unless the different period is fixed by the court. Okay? So the same thing, it should be verified, it shall be accompanied by affidavits, depositions, and other authentic documents in support thereof. Okay, so after that, there should be a hearing, that is section 3. After the comment is filed or after the expiration of the period for its filing, the application shall be set for hearing not more than 3 days thereafter. The facts in issue shall be proved in the same manner as is provided for evidence on motions. So this is self-explanatory, and we'll go to section 4. order. The court shall determine provisionally the pertinent facts, and shall render such orders as justice and equity may require, having the regard to the probable outcome of the case, and such other circumstances as may aid in the proper resolution of the question involved. If the application is granted, the court shall fix the amount of money to be provisionally paid of such other forms of support as should be provided, taking account the necessities of the applicant and the resources or means of the adverse party, and the terms of payment or mode for providing the support. If the application is denied, the principal case shall be tried and decided as early as possible. So, this is quite instructive. No? The section 4 of Rule 61 is instructive. So, it should be based on a probable outcome of the case, and of course other circumstances as may aid the proper resolution of the question involved. So, if there is a grant, the court shall fix the amount, of course, based on the need of the those who are of the applicants. I mean, the necessities of the applicants, and of course, it should take account also the resources of the adverse party to whom the support is uh, applied for. No, uh, if there is denial, the principal case shall be tried and decided as early as possible, of course, so that we will know the resolution or the outcome of the case. Okay, perhaps the court determines that some of the probable outcome of the case uh, may not be as favorable, no, to the decision. Okay, so in summary, this is the procedure, no, from sections 1 to 4. So procedure, application filed in court and served with adverse party. We can find that in section 2. Adverse party files comments within 5 days unless different period is fixed with service of application. Of course, in section 2 also. Application is set for hearing not more than 3 days after comment is filed and after the expiration of the period for its filing. That's section 3. And we have order, section 4. So the order, so we have discussed this already, that the court shall determine provisionally the pertinent facts and render such orders as justice and equity may require, having due regard to the probable outcome of the case. So the court shall decide based or with regards to the probable outcome and such other circumstances as may aid in the proper resolution of the question involved. So the effect when application is granted, as stated in section 4, that if application is granted, court shall fix the amount of money to be provisionally paid as such other forms of support as should be provided. The court shall take into account necessities of the applicant, that's number 1. Number 2, resources or means of the adverse party. And of course, the third one is terms of payment or mode for providing support. So, what is the effect when application is denied? If application is denied, principal case shall be tried and decided as early as possible. So let's go to section 5, the enforcement of order. So, if the adverse party fails to comply with an order granting support Pendente LIte, order of execution without prejudice to liability for contempt. Okay, so the court will or give an order of execution and then without prejudice to liability for contempt. So it is stated here that the person can be uh, guilty of contempt, okay, without prejudice to liability. Okay? Second, if the person ordered to give support pendente lite refuses or fails to do so, and a third party furnished that support to the applicant, third party may, after due notice and hearing in the same case, obtain a writ of execution to enforce his right of reimbursement. So, for example, there is a third party that furnishes the support to the applicant because the person ordered to give support pendente lite refuses or fails to do so. So, he has the right now to obtain a writ of uh, execution to enforce his right of reimbursement. So, as an example, if person A is ordered to give support pendente lite to person B, but another person, person C, it could be the mother, or it could be the or anybody, no? So who furnished that support to person B. Now, person C may, in the same notice or after due notice and hearing in the same case, obtain a writ of execution to enforce his right of reimbursement from uh, person A. Okay, so here are the here are several jurisprudence cases held in court. In Saavedra versus Ibanez Estrada, 56 Philippines 33, no? In 1931, an order for support pendente lite is intended to be operative exclusively during the pendency of the litigation. Hence, the voluntary dismissal of the action by the plaintiff has the necessary effect of abrogating the order. Okay, so it should be operative exclusively during the pendency of the litigation. It is instructive in the name, pendente lite. Okay, so in the pendency of the litigation. So if the plaintiff voluntarily dismisses the relief, no? Okay, it has the effect of abrogating the order. Okay, in Torres versus Honorable Teodoro Sr., 101 Phil 422 in 1957, where the court ordered support pendente lite to be deposited each month, failure of the defendant to deposit for 1 month is a separate and distinct violation from a failure to deposit for another month. Convictions for indirect contempt for failure to deposit for separate months do not constitute double jeopardy. So, in this decision of the Supreme Court, they interpreted that failure to give support for 1 month is a separate uh, offense if you failed again for another month. So, in other words, these are two separate offenses of the same thing, but it does not constitute double jeopardy. Okay? So, different offenses, different counts for each offense, okay, or failure to deposit or failure to give support based on a monthly perhaps or a quarterly perhaps. Okay? In Mangoma versus Makadaig, 90 Phil 508 in 1952. These are very old cases where the oppositor to an application for support pendente lite alleges sufficient ground to oppose support. For example, adultery by wife. The oppositor should be given an opportunity to present evidence in support of his opposition. Of course, there is a hearing, isn't it? There is a comment. So it should be heard that this ground should be heard, okay, during the hearing. In San Juan versus Valenzuela, 117 SCRA 926 in 1982, The trial court's order fixing the amount of support pendente lite is not final in character because it can be subjected to modification depending on the changing conditions affecting the liability of the obligor to pay the amount fixed for support. It is said in the rule in section 4 that the circumstance also of the person uh, to whom the support is sought is also considered. So also the necessities of the applicant. So the decision of the court to give certain amounts is not fixed. Okay, they can fix the amount, but it is not. It is subject to changes. Okay, so that's how it should be interpreted. Okay, let's go to section 6, support in criminal cases. So A, when is support applicable? No? Number one, in criminal actions where the civil liability includes support for the offspring as a consequence of the crime. Okay, so this is a self-explanatory. And then number two, the civil aspect thereof has not been waived, reserved, or instituted prior to its filing. Okay, so it is we have known that every criminal liability there is civil liability. So if that civil aspect has not been waived or reserved or instituted prior to the filing of the criminal action, so support is applicable or the application for support pendente lite is applicable. Letter B, who may file? No? Who may file support pendente lite? So this should be in successive order. So uh, number one, in the topmost, offended party. Of course, if the offended party does not file for support pendente lite, it could be the parents, especially if the offended party is a minor. Uh, and then second, if the parents or there are no parents or the parents are not willing, the grandparents or the guardian of that offended party in number one. Or if there is none in the doctrine or in the principle of parens patriae, it could be the state. So the state can file an application for support pendente lite. Okay? Number 7. Section 7, restitution. So when restitution is applicable, what is restitution? Restitution, by the way. So it seems that it is a uh, reimbursement of the money of the support that the person whom support is sought, uh, the money will be returned to him or her. So this is restitution because it was found out that the applicant is not do not have the right for such support. So when the judgment or final order of the court finds that the person who has been providing support pendente lite is not liable, therefore, so the person is not liable. So in other words, there should be restitution. Restitution, if we're talking about restitution, we are talking about a repayment of the, the things that caused him harm. Okay, it's different from damages, but it is as if to give to mitigate the things that happen to him, bad things that happen to him, such as uh, providing support that he is not liable of. Okay, so it is applicable when the court finds out. No? So the court has findings for that. So what court may order recipient? The court may order that the amounts already paid be returned with legal interest. from the dates of actual payment and without prejudice to the right of the recipient to obtain reimbursement in a separate action from the person legally obliged to give support. Okay? So, um, what does it mean? Well, with legal interest, of course, we all know that there is already a legal interest, which is, I think, 6% per annum. And the person can actually sought relief for reimbursement from the person actually uh, legally obliged to give support. So if the court finds out that it was person C who is obliged to give support, and then person A applied for a support pendente lite to person B, but the court finds out that person B is not liable for such support, but was granted beforehand to support A, person B can uh, seek separate action from person C for reimbursement. So that is what this section means. If recipient fails to reimburse, if the recipient fails to reimburse, the person who provided the same may likewise seek reimbursement thereof in a separate action from the person legally obliged to give support. Okay? So it's the same thing. No? If letter B fails to reimburse, so the person who provided the same may likewise seek reimbursement thereof in a separate action from the person legally obliged to give support. Okay, so um, this letter C who gives support to person A because person B fails to give support, but the court finds out that person B is not really liable for the support, and so person C seeks reimbursement from person D if person D was the one who is legally obliged to give support to person A. Okay, so the same thing. And that ends our presentation for support pendente lite of the Provisional Remedies, Rule 61 of the Rules of Court.